Competition Bill. Recently, the central government has proposed amendments to the Competition Bill, which was approved both by the Lok Sabha and Rajya Sabha. The main emphasis was given to reduce the timeline and ease of doing business and facilitate simple procedure for notifying for combinations. The Competition Amendment Bill 2023, which will pave way for reducing timeline for processing of combinations by Competition Watchdog, Competition Commission of India, got the Parliament nod on Monday in the last month. The bill was passed by the Lok Sabha in the March and was cleared by the Rajya Sabha recently. The bill proposes some changes aimed at improving ease of doing business along with increasing the watch on digital companies. The amendments to the competition bill is aimed at keeping the watch on digital companies and ensuring the ease of doing business improvement. According to the bill, overall the time limit for assessment of combinations has been brought down to 150 days from 210 days earlier. Further, prima facie opinion be framed on combination notifications within a time period of 30 days from the receipt of such notice, failing which the combination shall be considered as deemed approved. The bill also proposes to introduce value of transaction as a criteria for notifying the combinations. All deal values involving acquisitions, mergers and amalgamations exceeding Rs 2,000 crore having target enterprise in India shall be notified to the Commission for approval before their consummation. The new bill also proposes to introduce a green channel route for certain combinations. If a combination falls under this route, it would be deemed to be approved right upon the filing of combination notice. An exemption has been provided for combinations below a threshold limit based on assets or turnover of entities involved. If the combination is below the threshold, it will be eligible for exemption. The bill also proposes to introduce an explanation to clarify that turnover would mean global turnover from all products and services of a contravening enterprise. Until now, penalties levied by CCI were calculated based on the relevant domestic turnover of the contravening enterprise. After the amendment, the penalty would be calculated based on the global turnover of the enterprise. The Competition Amendment Act 23 has through an explanation to Section 27 of the Competition Act clarified that penalties for the abusement of dominant position under the Act shall be computed on global turnover of such enterprise. This would have far-reaching consequences for multinational enterprises doing business in India. The bill also increases the amendment also increased the scope of anti-competitive agreements to include agreements other than vertical and horizontal agreements which are anti-competitive in nature. The government has also proposed a leniency plus framework in the bill aimed to incentivize any entities being parties in a cartel in investigation to provide information on other existing cartels for a lighter punishment. It has also been proposed a settlement mechanism for entities being probed for antitrust violations. All these amendments to Competition Act will ensure the ease of doing business, and if any penalty is going to be levied, the penalty will be based on the global turnover of the organization instead of earlier position of domestic turnovers. And threshold limit of amalgamation measures exceed above Rs 2,000 crores has been covered, and below threshold limit of 2,000 crores, the small enterprise will be taken a lenient view for approving the combinations. An exemption has been provided combinations below a threshold based on assets or turnover of the entities involved. If the combination is below the threshold limit, it would be eligible for exemption. The bill proposes to introduce an explanation to clarify that turnover would be global turnover but not domestic turnover. The penalties for abuse of dominant position under the Act shall be computed on global turnover basis, which will affect mainly the multinational companies which are carrying on business in other countries as well as in India. This would have far-reaching consequences for multinational enterprises doing business in India, which are having substantial business in other countries. The amendment also proposes to increase the scope of anti-competitive agreements to include agreements rather than vertical or horizontal agreements which are anti-competitive in nature. The main purpose of amendments to the Competition Act is to encourage the competition among the enterprises, encourage any agreement which is anti-competitive should be penalized and should be covered, should be penalized, and the competition should be survived, competition should be protected, and all the small players, whether it be large or medium, small, should be in a position to have their share in the market based on their quality, service, price, all things. So efficient should survive, and there should not be any form of cartel or syndicate to prescribe or to carry on the business on monopoly basis, towards monopoly basis. They should encourage, the competition will encourage the better quality, fair price to the consumers, and also the better price to manufacturers. The main idea of introducing competition amendments to Competition Act to reduce the gap between the price paid to the manufacturer or producer and the price collected from the consumer. So that the gap should be reduced so that the producer will get the fair price and the consumer will get the product. The consumer will get the better price and better quality and timely supply of goods, which will be ensured with the amendment made to the Competition Act